One of the mysteries of medical law is the Medical Board of California's disciplinary process. The standard disciplinary guidelines are a small novel, and how they apply to real-life situations is part science and mostly magic. If you are facing medical board discipline, a stipulation does not have to reference why guidelines are being bypassed, but a recommended resolution requires findings that support deviations from the published guidelines. This is one of the many obscure rules that a top-level medical defense lawyer is aware of and uses to your advantage. Many physicians review the disciplinary standards online and find them to be dense and vague at the same time. The reason for this is that the disciplinary rules are dense and vague at the same time. There is nothing wrong with your reading of the rules. They are specific without specificity. They are detailed without providing real guidance. To better understand the endgame of discipline, let's look at how the MBC classifies cases at the start. In theory, the MBC prioritizes cases based on their severity and urgency. Complaints can originate from a variety of sources, including patients, colleagues, insurers, or even law enforcement. High-priority cases usually involve allegations of gross negligence, sexual misconduct, or substance abuse that could impair medical practice. These common types of cases never really fit into the same mold. Each case is different, but at the penalty phase, the medical board will try to put your case into a standard cookie cutter. Lawyers who do not regularly represent doctors may not be aware that the medical board has a triage system. The system ensures that complaints posing immediate risks to public safety are addressed promptly. For instance, if a physician is suspected of practicing under the influence, an expedited investigation may lead to an interim suspension order. When determining disciplinary actions, the MBC evaluates several factors. They assess the nature and severity of the violation and ask the question, was this an isolated mistake or a pattern of misconduct? More severe violations have strong penalties. An example is as gross negligence. Gross negligence, which will almost always be medical malpractice. Sexual misconduct is high on the list of severely punished conduct. Patient harm can worsen or less than sanction. Even a finding of gross negligence can be mitigated if the patient was not harmed in the long term. The obvious factor is the physician's past disciplinary history. Previous complaints or disciplinary actions will invariably escalate the penalties imposed. Top defense lawyers start mitigation immediately. You can both mitigate, which is a form of remediation that implies acceptance of fault with a strong defense. They are logically opposed to each other, but you can do both before the medical board. Mitigation can include taking specialized courses, paying restitution if money losses or theft are involved, or seeking psychological counseling. The mitigation conduct is case-specific, and a good attorney will tailor your mitigation to the facts or your case.
Medical board discipline requires experience and expertise. Daniel Horowitz's track record speaks for itself. If you're facing a challenge to your medical license, don't wait. Early intervention can prevent minor issues from becoming career-threatening. Contact the law office of Daniel Horowitz at 925-283-1863. Our experienced team will provide the defense you need. Your license is your legacy. Trust us to defend it.